Hi everybody, thank you for joining us today on today's webinar. The topic of today's webinar is on the recent stamp duty rebates and the recent case law that's come about at the end of January this year. So this webinar is aimed predominantly at property investors, property developers, landlords and people who may happen to have a second property. So just introducing myself, I'm Daniel March. I'm one of the owners of the company. I'm a chartered building surveyor and co-own the company with my partner Wayne Lamb, who's a chartered accountant. Our contact details are there for anyone who wants to jot them down. So running through the recent case law, the P N Bewley versus HMRC case. The case came about at the end of January this year, 28th of January, and basically a couple took HMRC to court. They purchased a rundown second property, and the legislation, the wording of the legislation basically says that stamp duty is payable if a house is suitable for use as a dwelling, if a property is suitable for use as a dwelling at the date of purchase. So this couple said it's a rundown property, clearly it's not suitable for use at the date of purchase, therefore we shouldn't be paying any stamp duty. HMRC said, well, if you spend some money refurbishing the property, £5,000-10,000 say, then the property would be fit for use, fit for occupation. So this piece of case law basically became about what is classed as suitable for use, and the judge ruled in favour of the couple and against HMRC. The judge decided that it's a day one assessment, and if the property was in poor condition at the date of purchase, then stamp duty isn't payable. So just moving on to the numbers, what did they look like? So the property purchase price was £200,000. The couple were charged £7,500 on that purchase. And the figures on the right are the commercial rates. So they basically said because it's not fit for use as a dwelling, commercial rates should apply, and that's what happened. So the couple were refunded £6,500 on a £200,000 property. So what can we do for you? So just looking through the numbers, we've compiled a bit of a list here. So showing the property values and the rebates that you would get if you wanted to take this forward. So on a £100,000 property, you'd get a rebate of £3,000. If it was, say, £250,000, it'd be an £8,000 rebate. So £200,000 to £250,000 is probably the most common value properties that we deal with, but we've also seen some much larger properties, particularly in the London area. So, you know, if you happen to have bought a property for £1 million in London, you would be entitled to recover £34,000 from switching it from residential to commercial rate. So moving on, what qualifies? Fortunately, the house doesn't have to look like this. So in the case in question, in the P N Bewley case, there were a couple of issues. So the property had no central heating system, and there was some asbestos in the property, although the asbestos was noted as being in good condition. Now what we'd say as surveyors is that if asbestos is in good condition, you don't touch it, you leave it. You know, asbestos is in millions of homes. It could be in artex and ceilings, or you know, it's everywhere. So we think that the criteria applied, or the issues that this property had, we don't think that they were, well, not saying that they weren't severe, but you know, it's not like it has to be a run-down derelict property for the rebates to be repaid. So in terms of evidence, the couple provided some photographs. They also had a statement from a chartered surveyor saying that in the chartered surveyor's opinion, the property wasn't fit for use at the date of purchase. and that I think is one of the areas where we think we've got an edge. Obviously that would be provided by myself, and then also obviously the relevant forms which my colleague Wayne would fill out. Moving on to the next slide. So I thought it'd be useful to provide some examples of the sort of issues that we're seeing. So these photos are from our clients. Apart from the roofing one, we've not managed to get a good photo yet. So if anyone has any roofing issues, please send that through. But basically, you know, these are the sort of issues that we think would be eligible. So if your property had roof leaks, or say if there were health and safety issues, so the second picture there is of a leaning chimney. The other photo is from a survey report we had from one of our clients, so that's defective lintel, Bresmer beam over the bay window, and you can see the crack in there. The lintel had to be replaced. The next photo is a photo showing some mould growth, which is another fairly common issue that we're seeing with the submissions that we're receiving. What we'd say about mould growth is that mould can create respiratory issues, asthma, conjunctivitis, you know, things that are bad for human health. So if a property has mould growth, then we would say it wasn't fit for occupation at the date of purchase. The next photo is fairly obvious, obviously missing bathroom appliances. Clearly it wasn't fit for occupation at the date of purchase. And then another common one that we're quite often seeing is electrics. There you can see that the fuse has burnt out. You know, if you've had to rewire, replace electrics, you know, because of health and safety concerns, then you know, we think that's eligible. So added a couple more photos in here. So the next top two are basically to show that not all properties have to be in you know, severely run down condition. The issue with these items is that there was no floor covering. So what we'd say is if you've got exposed floorboards, then that's likely to be a dusty environment. Again, dust creates respiratory issues, which is a health and safety factor. Similarly, if you had defective plasterwork or missing plasterwork, you've got exposed brickwork, you know, that would also create a dusty environment. Photo in the top right, that was as a result of some water ingress from roof leaks, but there's also the polystyrene ceiling tiles, which quite often are a health and safety issue because they're highly flammable. Bottom left is broken glazing. You wouldn't want your children running around in a property if there were, you know, if there was broken shards of glass everywhere. Next picture, obviously no kitchen. You can see that some of the electrics are on show. The final photo is showing missing floorboards. So that'd be a trip hazard, and you know, you couldn't live in a property like that without doing some form of work. So we've also created a list here summarising the issues that we think are applicable. So if there was nothing that jumped out at you before, please take a second to review this, see whether there's anything you know, that you can spot there that you've had issues with yourselves and your own properties. If you're unsure of anything, give us a call. You know, we're not saying that's an extensive list. We'd be happy to chat through other items with you. In terms of eligibility, what does it take for you to be eligible for a rebate? So there's four key things. The property has to have been purchased since April 2016, and the reason for that is that's when the stamp duty surcharge rates kicked in, which is the additional 3 to 15% if you're a landlord or already own a property elsewhere. The property has to have been empty or unoccupied at the date of purchase. Sometimes people don't always know the answer to this, but the reason for this is we think it'd be very difficult to say to HMRC that property wasn't fit for occupation if there was somebody occupying at the time. Clearly they probably have something to say about that. The only time, so we've got a couple of applications in progress Not heard back on those ones yet. But the only time where we would say that doesn't necessarily have to be the case is if something's cropped up that the previous occupier wouldn't have been aware of. So say, for example, the electrics were unsafe. That might be something that that person may not necessarily have known about, and that information only becomes it only comes to light once you've had your surveys done your due diligence. So we think there'd be grounds to argue that having done that due diligence, at that point when it comes to light, you would say that property wasn't fit for occupation. And so was the property unfit for occupation at the date of purchase? So that is basically, can you apply one or more of the items from the list in the previous slides? All it takes is one item. You don't have to have lots and lots of items. In the case law that we discussed, there were two issues. One, I would say, is a bit of a non-issue. Lastly, we would need you to provide some form of supporting evidence to support your application. It's no good you sort of giving us a list of issues but then not be able to substantiate it. So obviously within the previous case, they provided photos and they provided a statement from a chartered surveyor. That is what you would get from me, a statement as a chartered surveyor saying, in my expert opinion, the property wasn't fit for occupation. But what we would say is that the more that you can provide us with, the better. Any photographs, if you've got survey reports, if you've got builders' quotes, a schedule of works, builders' merchants' invoices, whatever you've got, send to us. Electrical test certification, but don't get too bogged down in it, because we've had a number of people who we've had these discussions with, and then weeks and weeks later they're trying to collate all the evidence. What I would say is, get what you can to us, and HMRC can always ask for more. So as long as we can prove one issue, one of those issues within the list, and then we can provide evidence to substantiate that, then that in itself could potentially be enough. And finally, if you do want us to act on your behalf, put an application in for a rebate, obviously fight your corner. Those are our contact details if you didn't take them down earlier. So all we would need from you is for you to email some basic details to info@sdsavers.co.uk. So there's a list there. We'd need the address of the property, the name of the person or the company that purchased the property. This does still the couple who bought the previous property, that was obviously bought within a limited company, so that's fine, it's not an issue. We'd also ideally like a bullet point list of the issues if they're not apparent from some of the evidence that you provide us. So if you provide us with a survey, obviously it's not an issue, but if you're just going to provide us with some photographs, but not everything is visible on those photographs, then it'd just be handy for you to bullet point list those issues to us. Any supporting evidence that you can provide, which we spoke about before, photos, survey reports, quotes, schedules of work, whatever you have. And then ideally a Rightmove link. It just allows us to check some basic information, the price and the purchase date. If let's say it was an auction property, you're not able to provide that, then just give us that additional information as well. In terms of our fee, so we operate on a no-win, no-fee basis. If we're not successful, you don't pay us anything. If we are successful, then our fee is 20% of any refund that you obtain. You don't pay us until you have received the refund. So the way we try to proposition it is, it's just so that it's a no-brainer for landlords. Regardless of how long the process takes, regardless of what HMRC come back with, you can't really lose. You just have to compose an email, which will take you 5 minutes, and then we deal with everything from there. And that's it really. So if anybody's got any questions, I'd be happy to answer those. So somebody's just asked, how long does the process take? What we typically say to people is HMRC aren't just going to roll over. You know, they're obviously going to try and retain as much money as they can. So, but what we've been saying to people is that doesn't really affect them. You know, like I said before, it's a fixed fee. There's no, you know, we don't work on hourly rates. You know, that's our issue. All you have to do is fill in the 5-minute application, and then, you know, the rest is for us to worry about and factor that into our you know, our costs. But yeah, typically 2 to 3 month process. There's another question here which says, can the case law be applied for new properties going forwards? This is a tricky one. We've had quite a few people query this with us, and the problem is, because it's such new case law, the solicitors don't really know what to do with it. And so everybody who we spoke to date, they've not wanted to jeopardize the sale and upset the vendor, so they've paid the stamp duty, and then they're going to go down the rebate route. But if somebody does want us to provide a statement, so we have got a service where we charge £500 upfront cost, where you would get 2 letters from us. So one is from myself as a chartered surveyor, basically providing a statement that, in my expert opinion, the property isn't fit for occupation, and then the other is from my colleague Wayne, my partner, who's the accountant. So he would write a letter which basically says that the stamp duty the property is exempt from stamp duty on the following grounds, in accordance with the following case law for the following reasons. So, but like I said, we've tended to find that people, they would rather pay the stamp duty, go down the rebate route, because the other thing is there are no guarantees. So it's just you know, potentially speculative money, potentially abortive fees if it doesn't go your way. But yeah, that's it in a nutshell. Send over, if you want us to act on your behalf, send over an email with the details that we've listed there, and any queries, please get in touch. Thank you.